My name is Lewis Hamilton. I'm the President of the New South Wales Society of Labor Lawyers. Before we begin, I'd just like to acknowledge the traditional owners of the varying grounds in which we meet this evening and pay my respects to the traditional owners, to their elders, both past and present. I also thank our attendees for joining us this evening. Tonight we have a wide and diverse group of interests tuning into our seminar from across the spectrum of criminal defence and prosecution, and also more generally just interested members of the legal profession. To all those that are joining a Labor Lawyers event for the first time, I say particularly welcome. Along with our event last week on employee rights and the JobKeeper scheme, the purpose of this event is to provide our members and supporters with insight into the substantial volume of changes that you or your clients might be facing enacted in response to the COVID-19 pandemic. Extraordinary times have called for extraordinary measures. But in times like these, when people look to government to take actions that may go beyond the ordinary practice of government power, we must also always be vigilant in ensuring those actions are proportionate to the threat faced and limited in their duration. And that gives rise to the topic for this evening's seminar. We have a distinguished panel tonight looking at these issues and presenting to us on the implications of the state and federal public health response in respect to civil liberties and criminal justice in Australia. Our panellists are Phil Boulten SC, Penny Musgrave, David Buchanan SC, Hament Dhanji SC, and Sam Pararajasingham. Mr. Boulten, Buchanan and Dhanji SC and Sam Pararajasingham are barristers at Forbes Chambers, Sydney, a chamber that's recognised as one of the preeminent chambers for criminal law practice in Australia. Penny Musgrave is the principal of Musgrave Legal, a criminal defence firm in Sydney, and has a wealth of experience, including 7 years as director of the New South Wales Criminal Law Review, which advised the New South Wales government on reforms to the criminal law in New South Wales during that time. All speakers are distinguished and experienced, and we're very honoured to have them addressing us this evening. I'm sure you'll join me in welcoming our panellists. But before we begin the discussion tonight, just some very brief housekeeping. During the discussion, our panellists will have the opportunity to field a number of questions from the audience. If you do wish to submit a question, you can do so via the chat or Q&A functions, which you can access at the bottom of your presentation screen. Although we cannot promise that each and every question can be addressed in the time available. We also do ask that throughout the main presentation, you keep your microphones on mute unless directly speaking to a question. Without anything further from me, I'll now hand over to Sam, who'll be moderating tonight's discussion. Thank you very much.
Hi all, thank you, Lewis. I hope everyone's managing as best they can in the circumstances. These are uncertain times, but perhaps there's some certainty around the corner. As Lewis said, look, really the purpose of this webinar is to kind of prompt discussion about some of the measures that have been introduced in New South Wales in the last 6 weeks. It's not intended to be comprehensive, and what we're really interested in doing is hearing some of the thoughts or musings of our panellists. As Lewis said, feel free to ask questions using the Q&A function or the chat function. Just to kind of kick things off, can I put this to the panellists? In any liberal democracy, at any given point in time, there is a negotiation between the assertion of civil liberties and the necessary reach of the state. That negotiation is often context-driven, and the touchstone is proportionality. And we've seen this throughout history. There's nothing kind of unusual about it. Can I ask this? In a pre-COVID world, how would you describe the way that balance between civil liberties and the reach of the state, how has that been struck in New South Wales in a pre-COVID world?
Well, whenever there's an issue that concerns the balancing of civil liberties against the need for measures to protect the community or apparently protect the community, in pre-COVID world, there'd be debate about it, there'd be discussion in the community, there would be lobbying, there would be parliamentary investigations, there would be legislation considered by Parliament, there would be upper house consideration, there would be publicity, there would be ventilation. But normally, as we all know, civil liberties do seem to get the thin edge of the wedge, even in that process. We haven't seen much of any of that for any of these provisions that are now operative and have been for the last 5 or 6 weeks. But this is an extraordinary time, as we all know.
So is it right to say that in a pre-COVID world, these kinds of negotiations are marked by consultation and the government prosecuting its argument, for example?
Yeah, to a greater or lesser extent. I mean, to be honest, we've seen tranches of anti-terror laws passed through Parliament with hundreds of pages being discussed quite preemptively with little or no discussion in Parliament, and most members of Parliament not having the foggiest idea about the detail. But, yeah, it is usual for there to at least be some sort of discussion, consultation, debate even.
So I think it'd be right. I mean, it was there, but it wasn't perfect. So there was consultation in the community and with stakeholders. There was parliamentary debate, and often that discussion and debate on occasion might lead to amendment, and on occasion you might be lucky with safeguards. And although not perfect, I think there was a degree of comfort in the general community about how that was working, which is perhaps why what has happened was able to happen so rapidly. And it's really only when you dig into the detail that you realise just how fundamentally this differs from what we've been used to in the past, and how consultation and parliamentary full debate about changes is so important, because we have lost a lot of safeguards, and we've also in this lost the capacity to debate future changes, and that is very scary.
But let's come to these this suite of legislation that's been passed. Can I ask you, Hament, how would you, at a very kind of abstract level, characterise the current approach by the government to that balance that we've been briefly discussing?
Well, clearly enough, as you've indicated, you're looking at always needing to strike a sort of necessary balance, and you referred to proportionality being the touchstone. We have a situation where, obviously enough, we are currently living through restrictions unlike any that any of us have previously had imposed upon us in our lifetimes. And prior to the pandemic, indeed, probably hadn't really conceived of a situation arising where within a matter of days we'd be faced with restrictions on our movement and restrictions on our freedom of association, such as we now have imposed upon us. But you're always going to have, I think, the other side of the coin, and that is we obviously do have institutions, and they're there with a purpose and need to step in cases of what I think can be fairly be described as an emergency. And I think there's also, I think, a danger in sitting where we sit now and taking the view that we're all becoming a little bit more relaxed because of what we've seen in terms of the dropping of the number of cases, or the flattening or close to extinction of the curve. I mean, what I think I see in the current context is some measures. I am concerned, obviously, enough about them being subject to review and change, but we're sort of seeing that happening, there is proposed to be some relaxation in the coming days. There's going to be need for further consultation, but it's very unlike, say, the terror type example, where in terrorism you get this situation where, of course, you have essentially a kind of people with ideas that are fundamentally opposed to the state. They have, in reality, very little power in terms of opposing the state, and so the means that they engage in is terrorism, and that in and of itself is designed to evoke fear and it's effective in doing so. And the real danger in those situations is that you have this level of fear that results in legislative change and restrictions and loss of liberties that's actually disproportionate. And that's a sort of classic example of where you get a disproportionate result, and it's all because of the very design in the terrorist sort of aims, that is to create maximum fear. But in terms of how rational our response to that fear is another question. Here, we've got a situation where, certainly speaking for myself, I as a lawyer, with no medical expertise, don't have really much of an idea, and I'm forced to rely upon the opinion of experts in terms of what needs to be done to ensure that we actually don't suffer a widespread loss of life. It does seem to be a real problem, and does seem to be a rational fear, unlike what's inspired by terrorism. And so I don't see, I see that you're never going to get it exactly right, particularly when you're acting so fast. But I think there's been a response which has resulted in significant restrictions, but it's also seen significant benefits accrue.
We'll come to some of the specific provisions, but can I just ask you this, David, just again at this kind of high level? The safeguards, or one of the safeguards, or the safeguards include the sunset clauses, the repeal provisions. I mean, for you, is that effective, sufficient in the circumstances?
Well, I don't know about you, but I have to say that when I read provisions like that, I think the potential for the time limit is to be extended. It sort of really stands out at you, and even if you were to regard the limitation periods as reasonable, you can see that it will be really, really easy for those periods to be extended, albeit on the reading that I've done so far, probably it will have to be by legislation rather than regulation. But nevertheless, the speed with which this legislation went through is, and the lack of input, and the lack of opportunity for input is enough to warn us, perhaps, that if it happened before, it can happen again with the very same provision. And secondly, as far as the provisions themselves, 6 months from here is a long time. I know it's actually 6 months from a month ago, but they're long periods of time, and in some cases 12 months. I don't know whether it's appropriate to say it now or not, but it does make one wonder if the rationale is that, well, it's a public health risk for the members of Parliament to meet together and perform their legislative function. Then there are plenty of examples, a Google search will show, of legislatures in other countries and other regions which are experimenting with remote participation in legislative debates and in recording of votes. But it doesn't seem to me that there's even been discussion, let alone serious consideration, of the options for doing that either at a state or a national level here in Australia. And I just find it difficult to believe that there wouldn't be practical options in this day and age of remote communications.
Yeah, I mean, the fact that Parliament's not sitting, put aside this idea that they ought to be legislating rather than just regulating. just sends a bad message anyway. I saw a woman on the media the other night saying, well, I'm a teacher, and if parliamentarians are finding it too dangerous to go to work, why should I be forced to expose myself to the virus in circumstances where I've got to mix with 30 kids every day and a whole pack of teachers? But I have a question for the panel too, because the sunset clause, the 6-month sunset clause that relates to the minister's health pronouncements, I heard that it runs each time that he makes a pronouncement. So every time that there's an amendment to the structure of the provisions, there's a new pronouncement. So there's a suggestion running around that it's sort of like a variable starting point, and it could go for 6 months, and who knows?
Because it's not an amendment of the primary order; it's a fresh order.
Yeah.
Mm.
I don't know the answer.
No.
I mean, it's a.
Anyway, that's got a bit of traction in social media the last couple of days. I don't know what the answer is.
Can I actually? I just want to, at that point, though, pick up on what David was saying about Parliament not sitting, because that concerns me when it comes to the regulations. And I don't know that the order, I don't think, falls into this category, but with a regulation, it of course has to be, it gets tabled in Parliament 14 days after Parliament sits, after it's been published. I can't remember the exact detail, but regulations don't just float under the radar. They do actually get brought before Parliament, and Parliament can move a motion to disallow it. If Parliament's not sitting, that means that we actually just have regulations in place with no scrutiny at all for 6 months. And that is, you've got to also look at that in the context where the reg-making power in the attorney's portfolio, in the legislation about, well, the one that has all the pre-recording, and I can't remember the name of it, it actually allows the attorney to amend by regulation any act in his portfolio, and the regulation can amend the law. It's not constrained by the reg-making power within the Act. It's only constrained by the reg-making power in the COVID legislation. Parliament not sitting is a massive concern in that respect.
Well, let's dive into it then, and we'll start with that point that you've raised, Penny. There is and so what we'll do is we'll look at probably the 3 key aspects of the COVID-19 Legislation Amendment Emergency Measures Act. I'll call it the amendment. One of the key aspects of it is this regulation-making power for exceptional circumstances that's set out at Section 366. Can someone tell us the effect of that provision?
Well, as I read it, it means that, in any act there's a regulation-making power, but the regulation has to be limited to that reg-making power. This act basically says that any of the relevant acts, which includes any act in the attorney's portfolio, can be amended by regulation, and that regulation won't be constrained by the reg-making power in the relevant act. It can extend to amending the law in that act, and the only constraint will be I think there's 4 sort of areas that are covered from memory, but it is an extraordinarily broad reg-making power.
So during the course of parliamentary debates, as brief as they were, this was referred to by many as equivalent to a Henry VIII power, right?
Well, it is a Henry VIII power. It's not, it's devolving law to the executive, and it's basically the minister in consultation with the Chief Justice. So just so that everyone understands, a Henry VIII power is effectively permitting the executive to legislate without reference to Parliament. Yeah.
Is that a fair...
That's right. And because Parliament's not sitting, the ultimate oversight by Parliament has been removed.
Now, Hament, there's a real question about the necessity of a power like this, isn't there?
Oh, absolutely. Absolutely. I mean, it is, as Penny said, it's an extraordinary power. And, you know, in my very general overview, I think, you know, my view was, yes, of course, you know, we have, you know, fairly extraordinary times, and insofar as there's a fairly immediate need to impose restrictions on movement, restrictions on association, one can understand that coming in very quickly. But sitting with that is clearly the need to be able to review those things and then keep a check on executive power in the context of those things, so that you don't have a situation arising where we all accept that there's an emergency, where we all accept that there's a need to do things that we would otherwise not do, but then we allow that exercise of power devolved to the executive to go unchecked.
I mean, some would say, look, there is a safeguard in place, which is that for basically for most of those matters, you need the consent of the Chief Justice and, if required, the head of a particular jurisdiction. I mean, is that a sufficient safeguard for a power of this nature?
No, it's not, and it's not about any personal view that one might take about a particular Chief Justice or a particular head of jurisdiction, and it's not unlike, you know, what happens in, you know, I suppose a court case that might involve, you know, an allegation of, you know, perception of bias. You're not talking about actual bias. You're not talking about the being able to establish that the person's going to act, not act impartially. You've got a situation where we have a system of government in place, and we have a parliament, we have an executive, we have, albeit at a state level, not the same strict separation of powers that we have at a federal level. We have these institutions and a legitimate expectation that they'll operate in a particular way, and a kind of a danger of setting particular precedents. And to an extent, in one sense, it might be that, you know, I've got a particular view of the Chief Justice, but why would some other individual who has not involved in the law and knows nothing about the Chief Justice, I mean, what are they supposed to make of that devolution of power? But it's also, we're not talking about the individual, we're talking about a person in a particular role, and that the person in that role might change from time to time. If you're allowed in this instance, what's to say you're not going to allow such a system in, you know, another instance where I might have a very different view about the person in that particular role. So you can't sort of, you know, gain satisfaction, or you can't gain much satisfaction, at least, from simply saying, oh, look, you know, we've got very trustworthy people in these roles.
Now, I agree. There is a division of power. It's a non-judicial function for the Chief Justice to be involved in the process, which I'm sure is probably better than anybody else in the state to have regard to what's happening, but, you know, it's not really a job for a judge. And I want to just pull into play an analogous situation in the ACT, where the Chief Justice there proactively sought out a change in the legislation there to dispense with jury trials over the objection of the accused for the first time ever anywhere in Australia, went out on a limb publicly backing the legislation. It was apparently her idea. And then when it was enacted, she said what a good thing it is. This is a very unfortunate development, not just the substantive law, but the fact that the Chief Justice is seen to be a political mover in this context. So it's not too far removed from what's happening now in Australia to think that there will be a blowback against judicial interference in the regulation of people's freedoms and freedom of movement and freedom of speech. So it's a remarkable thing. I'm blown away by what's happened in the ACT. That's just the most extraordinary thing.
Phil, I think it's really timely to raise that, because one of the concerns I've got that is going to come out the other end of this is the criminal justice system is going to have its own crisis, which is going to be delay. And the heads of jurisdiction are going to be very concerned about that issue. So I do think we have to be very alive to the interaction between heads of jurisdiction and the perpetuation of any of these approaches that have been taken, because we are going to have our own crisis in 12 months' time.
Well, we've had a history of significant delays in our courts before, and it's
going to be so far worse, Hament.
Yeah, well, we'll have to sort of wait and see. And I'm not, I mean, it partly depends upon when everything starts going back online.
True.
And so I'm not, you know, I think it's sort of up in the air at the moment as to what the delays are going to be like. But it does raise, I mean, if you're right and they're going to be, you know, more significant than anything we've seen in the past, we're going to see, I think, a lot more communication between heads of jurisdiction and legislators. And there is obviously a risk that we're going to see things that are significantly worse than what we've already got, such as the pre-recording ideas.
Can I just pick up something that Phil said, which is kind of can move us on to this judge-alone trials issue? There is provision for that in what I'm calling the Amendment Act. Significantly, it requires the consent of the accused person. Phil has raised what's happening in the ACT. David, can I kind of ask you this? So within the relevant provisions in the ACT, it provides that the court may order that the proceeding will be tried by judge alone if satisfied the order, A, will ensure the orderly and expeditious discharge of the business of the court, and B, is otherwise in the interests of justice. The Attorney General of the ACT said this: I believe that providing the mechanism to allow judge-alone trials with these safeguards, and for the most serious offences during this time, will reduce the real risk of disease transmission among jury members, members of the legal profession, and court staff, as well as preventing a significant backlog of cases. Now, surely this is nothing more than pure, unadulterated efficiency. Isn't that all that this is about, David?
Well, that might be at the front of the mind of those involved in the legislation being passed. But again, I don't know what consideration was given to the alternatives. And again, I can't believe that it wouldn't be possible to manage a jury trial in a way such that a jury remains involved, but that public health can be attended to. Deliberations might be the biggest issue, but I would have thought that spacing of jurors around a jury, around a courtroom, can be arranged such as to allow the jury to participate in the trial in terms of seeing and hearing the evidence being taken.
Well, I've been running not many, but some jury trials.
Yeah. So I gather.
The other interesting thing, I think, is you're looking at a measure like that's come into play at a time when there's actually, you know, we still don't know as much as we need to know about the transmission of this disease. So it's a fairly extraordinary step to take when it might well be that, you know, as we learn more, we actually work out ways when we can deal with it in a far less drastic fashion.
Yeah, it's not as though the ACT's got a large backlog of cases either, to be frank. You know, like anyway.
It used to have one. It used to have a big backlog. I don't know about its current state of delays, but it might be that is weighing heavily on the mind of the Chief Justice.
Well, it must be.
He wants to avoid a recurrence of that because it was the subject of editorials and media criticism and political criticism, and she probably wants to avoid that happening to her again.
Yeah, well, most of the problems with the criminal justice system in the ACT revolved around judges when they were sitting as judge-alone arbiters of civil and criminal cases, being reserved for 12 months, 2 years, 3 years before deciding whether someone's guilty. Had nothing to do with juries.
Yeah, I think there's a significant concern in relation to some particular judges with very long reserved judgments.
Indeed.
And just before we move from this discrete issue, there is, as I'm sure you're aware, there was very recently an application made at the court's own motion in the ACT, the case of R and UD, before Justice Elkheim, citation 2020 ACT SC 90, in which both the Crown and the defence opposed the making of the order, and the order was made.
Yeah, so the order's been made. There will be an appeal heard about that order probably pretty soon, but I would be staggered if part of the challenge does not involve an assertion that this is not a Chapter 3 court, or this is not justice, or this is unconstitutional, as opposed to an appeal just being based on the merits. You know, it's like crazy.
People have been openly saying that it's on a fast track to the High Court.
So it ought to be.
Yeah.
All right, let's now move
By the way, Victoria's legislated to introduce judge-alone trials for the first time, and people have been clamouring for that, including lots of defence lawyers. Now it's come in because of this, but of course their measure is much the same as ours, so it can't be forced onto an accused.
But one thing that I think may arise, given how, depending upon how things play out, I mean, if Penny's right in relation to the delays, and I'm not saying she's wrong at all, it's definitely a possibility that we could have very substantial delays. If we do find a situation where there are very substantial delays, you might find accused people being told, well, I can give you a judge-alone trial, that is, accused people in custody. I can give you a judge-alone trial in a month's time, or you can wait for a year, 18 months, 2 years for a jury trial.
Well, that's happening now, Hament. The judges are telling people, all right, if you want a jury trial, well, you won't be getting one until October. Otherwise, you can have your judge-alone trial in 3 weeks. And what's more, if you lose it, you'll get a discount because you've been facilitating the course of justice by going without a jury.
Is that in relation to people in custody? I've had that certainly for a client on bail.
Wow.
It's been... Yeah, I think it applies to people in custody.
Yeah.
Yeah, in fact, they've got the priority.
No, I've got no doubt. And you know, the bar has been lobbying for a special identifiable COVID-19 discount for pleading guilty. People are going to get a discount for pleading not guilty and losing. Then surely they ought to be incentivising pleas of guilty at the moment. But none of that's actually been taken up by the government just yet.
They can't debate it. They'd have to do it by regulation.
Well, they can do it by regulation over a scone with the Chief Justice.
Yeah.
All right, let's move to the third kind of key aspect of the Amendment Act, which is the pre-recording of evidence. Now, that as a concept is not new, applies in the case of, for example, child witnesses in prescribed sexual offences. But looking closely at this provision, this seems to go significantly further than that. The categories of witnesses is expansive, I'd suggest, and it's an order that can be made in the absence of the consent by both parties. What does anyone make of this aspect of the Amendment Act?
Well, Penny's got a strong view about it.
I won't go into the details of particular matters. But with the court making the order on its own motion, and I'm not across the legislation, I haven't done a pre-recording under the provisions, but I think the parties have to be heard. But it's an interesting way it's been drafted, because the judge has to take into consideration the interests of the wishes of the victim and the availability of court facilities in making its decision, which it's just very interesting as to what the significance is of any other consideration when they're making that determination. So yes, it's on its own motion. Yes, the parties have got the right to be heard, but the prime consideration appears to be the victim's wishes and the availability of court facilities to hear it. The interests of the accused seem to have very little role to play in it. Yeah, I've got very strong views about the disclosure aspect. Is that the bit you were talking about, Phil, or did I rant about something else?
As you've told me several times, what a waste of time it is.
Oh, no.
Pre-record the evidence in real time.
Yeah, and then play it again.
Wait for a trial and then do it all again. So it all takes twice as long, more than that, because before it gets played in the real trial, someone from both sides has to sit and look at it, review it, work out whether or not it's all kosher to go into evidence, edit it if there are objectionable pieces, or if there are issues that are apparent after the recording that weren't apparent at the time of the recording. So it's just going to cost a lot more money, which is all right if you're a prosecutor and a judge and you're going to work every day and you get paid the same money every day. But if you're the accused, it means you're doubling the cost of a trial.
Look, absolutely. And I don't know what Legal Aid's position is on it. And it also means I don't really understand what the point of the provision is, because with the expanded category of people who can be pre-recorded, the third category, which is just people generally, they have to have some vulnerability. But I think it's complainants in sexual assault trials, I can't remember, and then complainants in matters involving violence, serious indictable involving violence, and then people more generally who've got a vulnerability. So why have they expanded the category of serious indictable involving violence? What's achieved by it? Because efficiency is not achieved. And the other aspect of inefficiency too is the fact that disclosure is not locked down. You have to supposedly have to have complied with your disclosure requirements in order to get the pre-recording order. But we all know there is no sanction for failure to comply. We all know that there has to be ongoing disclosure. We all know that material is going to be disclosed leading up to the trial proper. And frankly, unless there's a requirement that the Crown has to open and they are locked into that opening with some sanction if they fail to comply with that or open in another way, or that there is late disclosure, then the pre-recording is not the pre-recording of evidence that is going to be given at a trial. It is a first round of recording.
Yeah, and the Court of Criminal Appeal has been critical. I would draw that. The Crown in the Court of Criminal Appeal has been critical of pre-recording in its normal everyday sense,
now,
where the complainant hasn't been cross-examined about issues that ultimately were relied upon in the address to the jury. And how do you do that if you don't really know what all the issues are at the time of the pre-record? There are also issues of security as well. I mean, the court has to have regard to availability of resources, court resources. That seems to be being interpreted by trial judges as, well, if we haven't got a courtroom or court facility or a remote recording suite at court available at the moment, we'll allow the witness to give their evidence from their lounge room. And this includes in cases where there are multiple complainants, where the complainant's mum and dad are important witnesses, and there's no sheriff going to go around to their house to sit there while the evidence is recorded, and where mum and dad are going to be in the kitchen watching.
So you're raising an integrity of the process.
Yeah.
What about, just for, say, our listeners or viewers who might not be involved closely in criminal law? I mean, what does this process whereby the evidence is pre-recorded well in advance of the trial, well in advance of a Crown opening on a case, I mean, how does this sit with the fundamental concepts of a criminal trial?
It changes them dramatically, because one of the things that you normally hold very dear is obviously your right to silence. And whilst if one is required to cross-examine a key witness well prior to trial, and if part of that includes the obligations to put various kind of aspects of your case, because you're going to be leading that evidence later, you're going to be disclosing an awful lot. And you certainly, it's a little bit like, the record of the interview where the person says, I don't want to say anything, and the police say, well, I'll just read this out to you just in case you want to comment on it. But in this instance, you're sort of obliged to actually enter into the fray and make your comments. And obviously enough, when the trial comes around, that as has already been indicated, that's when the Crown's actually going to open. That's when they're going to present their case, and by that time they might have learnt an awful lot about what your client's position is.
It's a serious breach of the principle that an accused should not go to trial before knowing, brackets understanding, close brackets, the case being made against them. What do they go? They need to know what the case is that they're being called upon to meet.
And David, I think they've tried to address that in the legislation by saying you have to have complied with your disclosure requirements. But we know in practical terms,
I hear you,
that the duty of disclosure is ongoing, and sure, you might have complied with your disclosure requirements at a point of time, but as Hament has said, you are, through cross-examination, matters are going to arise, and the prosecution would argue that they're remiss in their obligations if they don't follow things up. So you will have it shifting unless there is something that locks them into a position. And all you're saving there is, I'm not sure. I'm not sure what you're saving. I don't
and on the
quite understand.
On the disclosure, even with trials as we have now, we see plenty of judges who, weeks into the trial, are very enthusiastic to embrace, Crown ideas for new evidence that they want to suddenly bring in.
Yeah, look what I found.
Change the indictment, change the charge period, change the offence.
Yeah.
And the delivery of a Crown case statement to the accused in adequate time before the trial, commencement of the trial, before the pre-recording of the evidence is not an adequate balm for this?
Not without some sanction for amendment.
And
I suppose I'm asking also, though, is a Crown case statement an adequate substitute for a Crown opening?
No.
No, and particularly if they're not locked into it and it can be changed. It can just be changed.
And so you sort of got, as Penny has said, this very little advantage, and you're giving away an awful lot. And so again, I suppose you can always say, well, look, this is a crisis time and you're going to be balancing some interests against others, but the balance here is completely one-sided. There's really nothing to be gained, and very significant change to fundamental things about the way a criminal trial should be run.
Now, in terms of the way legislation would work, and there's a similar provision in the existing pre-recording provisions to do with vulnerable witnesses or child witnesses, there is a provision to make an application to question the complainant or for the complainant to give further evidence with the leave of the court. My question, Phil, is, I mean, in practice, I mean, are such applications being made and granted, or is it a very rare thing to see occur?
Well, look, I don't know. I haven't been into a courtroom for about 5 weeks, to be honest, but in a real courtroom. But I have heard that these applications are being made. So a colleague asked me yesterday about his particular circumstances, where he has a trial at Parramatta that involves pre-recording this week, and that was what I was thinking of, amongst others. I've heard of others, where the witnesses were going to be giving evidence from their lounge rooms. Like it's actually happening.
And to your understanding, you may have said this, in the absence of any oversight, these people are just sitting there giving evidence.
Well, that's what was explained to me. I'm getting all of this secondhand, and it might have changed since, you know, I gave my 2 bobs worth to this fellow who was going out to run this court case. But he understood that there'd be no sheriff's officer there.
Who sets up the recording equipment?
Don't know. Who set your one up, David?
Yeah, I was about to say. Yeah, it's not hard.
All right, so that's all quite interesting, really, and there does seem to be some significant questions arising as to the extent of the reach in the Amendment Act. We've only gone to 3 of what I think are the key kind of provisions. Just to change tack a little bit, how has the current crisis affected the state's prison population?
I haven't heard the figures. Does anyone know?
In terms of rates, rates of incarceration, or just generally, Sam?
Generally.
Oh, got it. Oh, well, there are no visits. No one's allowed to visit the prison.
Yeah, that's what I was going to say. We wouldn't know. You can't get in.
The family and friends of prisoners all have to talk on the telephone. They are trying to set up video contact facilities in the major jails. But by the time they build them, probably the crisis will be over. But by then they might use them more anyway, and just tell people, well, you can't come on a Saturday or a Sunday. You can video in at an appropriate time.
I understand. I've got a client who's going to be able to do FaceTime this weekend to his family. That's the first I've heard of that. I'm hearing with legals there's been a lot of delays in getting slots through Just Connect. So even though lawyers can video conference their clients, there's big delays in doing that. I don't know whether you guys are hearing that, but that's what
I've got a client whose sentence matter was on Friday last week, after an appointment that's been on their books for like weeks, many weeks. The psychologist went to go to the jail and wasn't allowed in. Wasn't allowed to video conference because they wouldn't bring the prisoner down to the video suite because of the COVID-19 need to isolate him. He's a vulnerable man in his 70s, and they regarded it as too risky to bring him to the video suite. We had to, my solicitor had to spend a fair bit of time sorting that out. So, yeah, there are practical issues.
I got an email tonight at 6:28, which has had a disruption to some Just Connect appointments tomorrow, referring to some sort of technical problem that they've had. And so presumably there's going to be a whole lot of appointments that people have been relying upon in relation to upcoming matters that are going to be taken out of the diary.
The new legislation does provide for the expedition of the granting of parole for a particular class of inmate. Do any of the panellists know whether that's being...
Yeah, I know. No one's been released. They don't intend to release anybody unless there is a cluster of infection. The Corrective Services Commissioner has described this ability to release on parole as a protective measure, but they're not going to do anything about it until someone starts to die.
Yeah, I assumed it was just preparatory in case there was a crisis and they had to get people out quickly. I don't know if there's been any increase in the use of the back-end reintegration home detention. That was a possibility that they could use, but I've not heard. I've got a couple of clients who'd fall pretty well into that category who'd be eligible for it, and I've not heard any good news from them.
Well, I've got a client who's sentenced, who's a man in his 70s.
Yeah.
His solicitor wrote asking for consideration under this provision. They wrote back and said, no, we don't intend to even consider it.
Can't be initiated by the inmate. It has to be initiated by corrections. Yeah.
What about the way in which the current crisis is being reflected in the courts, for example, on bail applications?
People are getting bail.
And how has it been relied on in the context of bail applications?
Well, it's a helpful factor in show cause. The uncertainty of the impact of the virus on the prison population, the concerns that relate to infection by sharing confined spaces. It has triggered quite a number of sympathetic bail decisions. The prosecutors are by and large quite amenable to arguments that suggest that this is a factor that might tip the balance.
Might have a longer term impact too if there are really huge delays, because I got the sense that some of the decisions were seeing the delay caused by COVID as being a change in circumstances that justified the bail application. Yeah, so I mean, and that's something that will probably outlive the existing crisis we're in if the delays are as bad as I think they might be.
I think it's that, and also just the appreciation that, and I think there's been studies to this effect that, and it might seem reasonably obvious, but prisons it's very difficult to control spread of infection in prison. So there is a legitimate concern in relation to the prison population and managing the disease in the context of that.
I'm assuming that somehow we would find out if infection occurred in a correctional setting, but really it's a question I'm asking. Do people think we would read about it? Who would we hear it from? Are corrections likely to announce it, or is it more likely to come from health, if from anyone, or from a lawyer or a family member?
Or the Daily Telegraph.
Family through the media.
Yeah, so Justice Health is not corrections, and they do have a separate remit. I imagine that they would be required to provide the government with all the information that every other health service and health professional has to. I think we'd hear about it. we heard about the fact that several employees at the Long Bay Prison Hospital were infected, and measures were taken to isolate them. Thankfully, no one seems to have been infected in a prison just yet. God help us that they don't. You know, interestingly, some of the most repressive regimes in the world have taken the most liberal steps to free prisoners in this environment. There's been thousands and thousands of prisoners set free in South American countries, in Turkey, in other places. They seem to think it's...
If not the political prisoners.
If not political prisoners, exactly. But Iraq, Iran, they're letting them all out. Thousands and thousands of them.
We can do it in theory.
Oh, yeah. We'll do it if they start to die. Maybe.
Can I ask you now? Sorry, go on, Hament.
Oh, sorry, I was just saying, Penny was saying we could do it in theory. I was just saying, but only within 12 months of the expiry of the non-parole period.
Yeah, true.
But I was actually, I have been thinking about another aspect of this, though, and that is not so much in relation to bail, but, whether this may produce a more kind of acute appreciation on the part of at least some judicial officers as to the impact of sentences. And so, my experience has been that whilst we've had, home detention either in and of itself or as an aspect of an ICO, it hasn't been kind of warmly embraced, and it's generally been seen as really not much of a punishment at all. And I am wondering whether people are starting to realise that if you spend, 6 months on home detention, that is actually very significant restraint, because I think many of us are feeling, the impact, and our restraints are nothing like what they would be after, 6 months of home detention. And, a fortiori in relation to actual imprisonment, whether this produces some appreciation that just because a sentence of imprisonment is measured in months, it doesn't mean it's not actually a very significant punishment. But that's sort of amusing that we'll have to sort of wait and see on, I suppose.
I suppose it's also we're living a kind of a non-linear experience of it as well. I mean, it gets, in one view, increasingly difficult at an exponential rate. Then, as you say, a pure block of time. So it is a way that people can kind of get a taste for a form of punishment. So just moving on now from just in the time we've got left, the public health order that we've mentioned briefly. Clearly this order has the most kind of wide-ranging effect to people. In its terms, it's reasonably straightforward, but there is an interesting question or an intersection between the order and the exercise of police powers. I was wondering if anyone had any thoughts on that aspect of things.
Before we get to that, I mean, I don't know how straightforward it is, because we've got this list of things that, kind of are regarded as the reasonable excuse. But that's an inclusive list. The actual restriction is based upon having a reasonable excuse. And so you're starting off with a pretty vague kind of sort of limitation on people's movement and association.
Yeah, I don't leave home without a copy of the reasonable excuses. And I've always got it ready to, I know what to say. Immediately I'm going to be confronted.
At least you know that this weekend 2 of you can go out to someone else's house, and that has been added to the list of examples, I assume, is how they're going to do it.
Yeah,
yet, one could argue that it was always a reasonable excuse.
Maybe that's right.
Yeah.
Yeah.
So this is, the uncertainty is part of the oppression. You know, you've got young constables that really have no training in this whatsoever, with lack of guidance, arresting people for eating a pizza or arresting someone for having a practice run in their, for their L plates. And, you know, it's just, this is one of the nastiest pieces of this landscape. The inconsistency between states is very confusing. Now, we've seen a senior member of the government brought down by this. Don Harwin's lost his career, and no one could actually say what it was that constituted his offence. As far as I could see, he had a reasonable excuse under the list of reasonable excuses, and when pressed, no one would say exactly what it was that he'd done wrong. So it's, you know, this is just mad.
Yeah. In fact, I wandered into Westfield the other day just to have a look, and, you know, Gucci and Prada are still open.
That is not a reasonable excuse, Hament. You can't just go somewhere to have a look.
No, I was okay. As Phil said, I'd armed myself with my excuse. I was in the middle of a work day, and so I was looking for exercise. So I walked around the park, and then I walked through. So I walked through Westfield, but I did think it was interesting that you've got these, you know, Gucci and Prada and, you know, all of these stores are open, presumably expecting people to come through the door, and presumably there's people that, you know, regarded it as a reasonable excuse because they desperately need a new, you know, Prada handbag or something of that sort. I mean, and if they're pulled up, I mean, what are they supposed to, you know, I imagine a lot of people are going to be responding and saying, well, the store's open, why can't I go there?
The bloke got arrested in Melbourne for washing his car at a commercial car wash.
Yeah, and I saw a comment just come up on the chat. One of the participants in this was moved on from the cenotaph while paying her respects.
Yeah, exactly.
But isn't the whole thing compounded as well too by the fact it's a penalty notice offence? Which, I mean, has no one ever read the Law Reform Commission report about penalty notices and the need for certainty and the concern
Not really, I've never read that. No.
Yeah, but it does everything that the report says not to do, and that actually leads me into something I did want to raise in respect of these orders, which is, I mean, there was a newspaper article about the fact that a whole lot of notices have been issued in a disadvantaged area where there have been no reported cases of COVID, but they were being issued willy-nilly. I'm really concerned that we are going to have very little data on this at the time that people are going to be asking whether or not it should be continued or what we should do with it. Because as I understand it, there's been no request to Boxar to make sure they're getting stats on the prevalence of penalty notices and the distribution across the state. I don't know whether the rate of Section 32 applications has gone through the roof, how receptive the courts have been. And the lag with that sort of data, I think the data that's publicly available at the moment is back in December. I think March is going to come out soon, and that's all pre-COVID. So we're not going to have any understanding of the demographic distribution of the police exercise of their discretion across the state until we are well and truly in an argument about how long it should continue for. I just think that's a real lost opportunity. If they're going to do something extraordinary as these provisions, at least get something set up so you can assess them properly and get in there and go, whoa, that exercise of discretion really isn't working in that place, but it's not being tracked. We're totally reliant on Mick Fuller's version of events in all regards when it comes to...
Is he still spending time every day at his desk reviewing every single penalty?
Well, I think so, but at least he's acknowledging that discretion is the greatest police power in their armoury, or words to that effect.
So outside of New South Wales, sorry, mate. Sorry, Hament.
But I mean, he might be sitting there at his desk reviewing these things, but what information is he reviewing them on? Presumably the version of the...
Sure.
Constable and nothing else.
Yeah, I think he's knocked back 3.
There would be just a handwritten note on the ticket. Outside of New South Wales, 9 people were arrested last week for returning to the Tiwi Islands without spending 14 days in quarantine. I think as in Western Australia, homeless Aboriginal people were threatened with prosecution because they were in a public space, and there is no doubt that the people who are copping the brunt of these infringement notices are not well heeled, do not live in the North Shore or in the eastern suburbs. Twiggy Forrest, I see, was with his wife allowed to return to Australia without 14-day quarantine. And then he, no, I got the wrong bloke, not Twiggy Forrest. Kerry Stokes returned to Australia without 14 days quarantine, turned up in Perth, flew across to Canberra and was at the dawn service at the War Memorial on Anzac Day, all within days of his return from overseas. This fellow who infected a whole lot of people in Victoria, who caught the virus in Aspen, he hasn't been hit with a bluey. You know, it's very, very skew-if.
Yeah. Look, and it's not to say that there isn't a need for something to be done, and that it is the lack of certainty. It is the way it's been put together that does lead to some real concerns in the way it's being implemented. It shouldn't be up to the discretion of police.
And this is another problem with Parliament not sitting. There's no scrutiny. There's no select committees sitting, as I understand it, that are focusing on collecting this sort of information.
Yeah, I think committees are sitting. I think it comes... My concern really is the lack of consultation when it was put together. And I understand it was dealt with urgently, but it is that classic situation where you have to take a step back and say, what are you trying to achieve? There's common agreement on what you're trying to achieve. But when you look at the way it's been put together, because of the lack of certainty, there is a real potential for injustice to flow. And there needed to be a debate about, was there a better way of doing it?
I'm going to jump in there. We do have a few questions. Before we come to that, I just want to kind of finish on one other, or raise one other aspect of the legislation, this time the Commonwealth legislation and the very recent biosecurity determination in relation to contact tracing. David, can you tell us a little bit about that, and in particular, how, in your view, whether you think the privacy concerns have been addressed?
It's a bit hard to say. If you take the view that a statutory instrument can trump a statute passed by Parliament, then arguably they have been addressed. But I'm afraid when I read the protections, which occupy about a third of the instrument, the minister's determination, I say to myself, well, that's all very well and good, but what about court orders? What about, which are search warrants, subpoenas? And we've heard in the media, the various ministers saying, well, that is going to be addressed. The courts won't be, these will be court order proof, but they're not, as I read the minister's determination. And I'll feel a lot happier when legislation has been passed to back this up. And when is it that Commonwealth Parliament is sitting again?
Well, they're going to meet in May, but they had planned not to meet until August.
Yeah. In the meantime, it does seem to me that the data on a phone or in the central data bank would be liable to be obtained by warrant or any other sort of court order. simply because statutes trump statutory instruments?
So the Minister for Health announced today that all this data being held in the cloud would not be amenable
server somewhere.
Yeah, would not be amenable to subpoena by a United States court. I just think that that's wishful thinking.
Yeah, I'm not convinced.
Imagine that a US court would be convinced that they don't have the power to issue appropriate subpoenas to a US company for US held data. It's
been a suggestion that the data is on a server in Australia, albeit run by Amazon. But it seems a bit ambiguous there, a bit unclear. It's precisely where the zeros and ones are being held. So
in any event, irrespective of common garden variety subpoenas or warrants, the United States has extraordinary intelligence powers and military powers that have the practical ability to soak up just about every single computer tap in the world almost immediately. And so too does China. And we, as a member of the Five Eyes agreement, have ready access to what the United States is soaking up for particular purposes, admittedly. But for the government to say that no one will ever get their hand on this data seems to completely overlook all intelligence-related issues. It overlooks the power of foreign governments, and it overlooks fuck-ups and perfidy, which are in evidence regularly, including by members of the current government. Miss Stuart Robert, the Minister, is going to be in charge of a lot of the health data. Excuse me? Do we have a lot of confidence in this data or not?
Can I pick up on that and raise a question that's been posed by Pauline Wright? What is the panel's view of whether the US Cloud Act will apply to data from the new COVID-19 tracing app to enable US warrants for the production of the data? Will it be possible to legislate that possibility away?
Well, the answer to that one is the last question is no. I think I've expressed my views about the first question.
Anyone else have a view on that?
I don't have a different view.
No different view.
No, there's no different view. Yeah.
I've got another question though, and I'm not sure what the answer is. But David, the protections in the Act only apply to the data. They specifically don't apply to any secondary inquiries. And I don't quite understand how the app works, and I don't know quite whether anything. I don't know what else is held, but there seemed to be this limit on what was protected. It only extended to data on the COVID app.
When you say secondary inquiries, do you mean metadata?
No, it says that it doesn't include information obtained from a source other than the National COVID Safe Data Store in the course of undertaking contact tracing. So presumably you get data from the app and they go away and make inquiries. That is specifically not protected, so that there's no secondary protection.
And then having that data and the contact tracer writes it down.
Yeah, or makes a phone call to identify somebody or a location or whatever. That's not protected. It's only the actual ping. The ping is protected, but the derivative inquiry is not protected.
That seems to be right.
Yeah.
Can I just point out another thing, that in the determination, the prohibitions apply to persons, and which is a little bit of a worry, because if that is to be followed through in the legislation that is to be passed, if it's to be passed in May, then there's a lot of law that says a court is not a person.
Mm.
Yeah.
Yep.
Mm.
Sorry, Sam.
No. We might go to another question. So this is from Rose K. The amendments to the Criminal Procedure Act allows for pre-recording where it is, amongst other things, quote, in the interests of justice, unquote. What do members of the panel think might be the interests of justice in this context?
It's going to be whatever the particular judge you're in front of kind of feels like they want to do at the time, I think. Yeah.
What kind of categories of matters would fall under the interests of justice in this context, do you think?
Well, undoubtedly efficiency, as Philip mentioned earlier.
Mm.
That'll be at the top of the list.
I mean, in terms of, you know, what one can say, I mean, there's plenty of statements that, you know, those words are words of the, you know, widest, you know, kind of effect. And as soon as you sort of have your starting proposition as being, you know, these are the words of, you know, kind of wide effect, is why I sort of, you know, start with the proposition that it does very much depend upon who you're in front of and how they decide to weigh up the various factors. But it is going to be, you know, how it might impact on the trial, you know, what you might be able to say about difficulties in the trial being broken up, balanced, you know, all balanced against obviously the interests in efficiencies, but that's put against, you know, the point that Penny makes that, you know, how much efficiency are you really going to get?
Can I throw in here one of my, again, another drafting annoyance I have? You're not going to get any assistance from the purpose of the part that was inserted into the Criminal Procedure Act, which states that the purpose of the part is to enable criminal trials to be conducted in a way that is appropriate. Thank you for that. Good, excellent. That is not a. You would find no guidance in that expression of the purpose of the part to the extent that it's relevant in the interests of justice. It's sort of an aside, but I just had to throw in that complaint.
And Penny, can you raise for our audience the drafting point that we were discussing before the webinar started?
Oh, what were we talking about? I've forgotten already, David. Remind me. Stop it, Phil. There were too many. What was it? I can't remember.
It was whether the
that's right.
parties had to be heard if the court was making the order of its own motion.
That's right, and it was in relation to the AVL. So it was in relation to AVL, wasn't it?
Yes.
Yeah.
Right.
So it's a nice question as to whether or not, when the court is directing that the parties attend by AVL on its own motion, whether the parties have got a right to be heard on that, because the section says the court may on its own motion or on the application of a party order AVL.
And I think there's a comma between motion and or.
There isn't a comma.
Isn't a comma? Okay.
So you don't know whether the requirement for the part or the right of the parties to be heard applies to both the court on its own motion or one of the parties' application, or whether the right to be heard is simply when a party makes an application for it to be by way of AVL. Because at the moment, the court is just directing that the proceedings be by AVL. Now, I haven't raised an issue. I haven't said I'd like to say something about that. So I don't know what the response is going to be. 'Tis tempting, though.
It is.
It would be a way of clarifying how that section should read.
Mm.
We were doing, in response to Rose's question, one issue that would go directly to whether it's in the interest of justice to use this video link process is it going to work? So it's one thing for everybody to be in court and to beam in a witness on video link. It's another thing altogether for the accused to be on video link, the barrister to be on a different link, the prosecutor to be on a different link, the witness to be on a different link, whether or not the documents that are to be tendered can be viewed by the witness and the parties, so on and so forth. Not just when the system is working, but there are terrible access difficulties with the systems that are in place at the moment. My experience has been pretty poor, really. An hour and a half trying to get onto a district court judge for a sentence matter, failed to make the connection. An hour the next day for a different judge, failed to make the connection. The Idio Bede and McDonald conspiracy trial has faltered because the system just couldn't cope with all of the links that were required to be maintained when they tried to examine a witness through this method. And
I wouldn't be surprised if we see not too far down the track a situation where somebody an accused has kind of been on a link but has dropped out for a period of the trial. And so then you've actually got a situation where an accused who's got a right to be present throughout his or her trial has actually not been present for some of that trial. And that is a miscarriage of justice, is going to result in a miscarriage of justice to which the proviso can't be applied because of its fundamental nature.
But also communicating with counsel or solicitor. If the accused is being beamed in from a video suite, the barrister's in his or her chambers, the solicitors in their lounge room, how do they all communicate effectively about whether or not the next question should be asked, and so on and so forth?
We'll go to perhaps a final question. This is from Felicity Graham. Is the Commissioner of Correctives' outright refusal to consider an application for release to early parole under the new statutory provisions an administrative decision amenable to judicial review and an error in the nature of failing to exercise jurisdiction?
I think Felicity has answered her own question. What do you reckon, David?
I don't know. I'm not sure. What do you think?
Someone's going to give it a run, aren't they?
It's the best way to find out.
Yeah. Well, it's a failure. It's a failure to exercise jurisdiction when they have jurisdiction.
Yeah,
it's a refusal to exercise the discretion.
All right. We're just about out of time. If we could just kind of go around and this has all been very informative and get a kind of a final thought from each of you about all these provisions and your, if you can distill it down to a sentence or two. Let's start with you, Phil.
Well, it's a new era. Things are going to be different. Once everybody's on top of the virus, it's not going to go back to the way it was. There'll be a lot more emphasis on video links. We're going to practice in a different way. I quite like working from my lounge room. I'm very productive. The structure of chambers is going to have to be reviewed. There's going to be a whole lot of issues that are going to be beneficial to the practice of the law and the administration of justice. But right at the moment, we're copping it, and it's not straightforward.
What about you, Penny? What's your takeaway? My
takeaway. Look, there's got to be benefits. We have to change the way we work, and there are potentially some good things we can take away from this. but there are some bad things that we need to be able to talk to people about to ameliorate the negative effects so we can actually maximise on the positives. And I do think that the criminal justice system's crisis will continue for some time because we are going to take quite a while to get back on top of everything that's changed and the delays that have happened.
Thank you. What about you, Hament?
Look, similar. I mean, we have some, you know, fairly archaic practices. The idea of a number of lawyers all turning up to a room to stand in front of a judge just to find out what day a particular matter is going to be heard is, you know, costly, inefficient, and does really not much to assist the quality of the administration of justice. And so if we can see some more efficiencies gained in that regard, well, that's obviously to the good, but clearly enough, the danger is going to be the desire to look for those sorts of efficiencies which can be gained without costs, and having them effectively sort of bleed into areas where there's a search for efficiency that does come at a significant cost. And obviously, you know, the most significant one that's been discussed tonight is the ACT approach to jury trials, which I think, you know, as Phil said, is extraordinary.
And finally, David?
It's the obvious, really, to suggest that you need to really read all of this stuff from top to bottom, and then read it again, and then see the context in which it's made, including the pre-existing legislation, to get on top of it. It's you know, if we're going to work our way through this, we need to be on right on top of the all the different types of legislation that are being made and their statutory background.
Made all the more difficult in the absence of a sitting parliament.
Indeed, and it doesn't seem as if there's an intention to have them sit very much at all this year. Looking at the sitting timetable of the Commonwealth and the New South Wales Parliament, there's like 2 dots for the rest of the year, one in May and one in August or September, depending on which parliament you're looking at. It's really extraordinary, and you know, someone in the Labor Party should be having a close look at this. Quite frankly, it's.
I mean, is that to the extent that there's any agreement amongst you? Is that really one of the more kind of egregious things that panelists have observed in this period, that we do have this absent parliament? I mean, is that something?
Absolutely, and I think the point's already been made. I mean, there doesn't seem to be any reason why you couldn't have some sort of, you know, sort of technological approach. And to the extent that people say, oh, there are issues in relation to Parliament sitting that way, it's got to be a lot better than Parliament
not sitting.
Sure.
All right. Okay. Well, I'll hand it back to Lewis now, but thank you, panellists, for making yourselves available. And I hope people who've tuned in have gained a little insight and at least an opportunity to consider the types of issues that certainly are bouncing around your heads. So with that, I'll hand it back to you, Lewis.
Thanks very much, Sam. And David, just brief answer to your comments. My understanding is that there are a few members of Parliament that are running this campaign to bring more sessions of Parliament back this year. Off the top of my head, I can think of Rose Jackson, MLC, who I think has been running a campaign over the past few weeks. So I think there is a bit of movement there, but we'll see what happens. On behalf of the Society, I just wanted to thank each of you for presenting to us this evening. The discussion was informative. I speak on behalf of everyone when I say that their own practices, I think, will immensely benefit from your insights into this issue, particularly around the criminal procedure elements of the new COVID-19 reforms. We would in normal times offer you a gift for your time, but in the circumstances, you'll just need to accept only our heartfelt thanks from myself, from the audience and the Society. And for those that are new to us in the audience, I would encourage you to keep in touch with the Society online, attend future events, and if you'd like to take your support a bit further, become a member on our website, which is www.nswlaborlawyers.com. So in conclusion, thanks to everyone, thanks to our panellists for your participation tonight, and we'll now be closing the seminar. Thanks very much.